Welcome back, everyone, to the Employment Space. This channel was created to provide to you a 360-degree view of the employment relationship. Now, in episode 2, I provided a list of the 9 most important federal employment laws that U.S. employers should know. Now, if you're an employer in the United States, there is one particular federal law you absolutely cannot afford to misunderstand, and that is the Fair Labor Standards Act, also known as FLSA. And in this post, I'm going to highlight for you the 5 most important things every employer should know about the Fair Labor Standards Act. Let's get into it. Okay, everyone, let's take a look at the first consideration. And that is, typically employers ask themselves whether or not FLSA applies to their business. They can make that determination by looking at either one definition of covered employer under FLSA or another definition. And that would be enterprise coverage or the consideration of individual coverage. Okay. Now, under enterprise coverage, if your business has at least $500,000 in annual gross sales, you have at least 2 employees, and those 2 employees engage in interstate commerce, then you may meet that definition and then confirm that you are a covered employer under the Fair Labor Standards Act. Now, interstate commerce is also it's defined somewhat broadly. You'll have to talk to your employment counsel to confirm coverage. But typically that test of whether there is interstate commerce can be met through emails across state lines, or your payroll systems, or even your vendor relationships across state lines. But again, you can speak to your employment attorney to confirm whether you meet the tests under enterprise coverage. Now, the second option, if you don't meet enterprise coverage, is individual coverage. Okay? And under individual coverage, there is no enterprise threshold amount. You have at least 1 employee, and that 1 employee, their job role involves interstate activity. Okay? So it's very different than just engaging in interstate commerce. Okay, so the best thing for you to do is to speak with your counsel. In my experience working with corporations, most of them just assume, based on their employee count, if you will, that they're a covered employer under FLSA. I suggest that you speak with your employment counsel to confirm otherwise. Let's move on to number 2. And that is going to be the proper classification of your workers. Now, notice I didn't say the proper classification of your employees, even though that's important too. But that is because employers commonly have a mixture between employees and also individuals considered to be independent contractors. Either way, you have to properly classify them both. And under the Fair Labor Standards Act, as well as the Department of Labor, what's looked at is the economic realities of that relationship, not what you prefer to call them, not what the job offer letter says about them, not what the employee prefers to be called, or if there's an employment contract. The Department of Labor and the Fair Labor Standards Act looks at the economic realities of the relationship. Who benefits? Also, the degree of control is also important. Now, when you hear the degree of control, that typically connects to the independent contractor assessing if this individual should be an independent contractor versus an employee. But overall, the Fair Labor Standards Act and the Department of Labor is going to look at how much control you assert over the individual, over their training, who pays them, their schedule, who gives them the equipment that they use to perform their functions for the company. Okay, so don't get too excited about that. I actually could create a separate post about the proper classification of workers, but that's more of a confidential, one-on-one, case-by-case conversation. Okay, so just be very careful of that, because the misclassification of employees seems to be the most expensive and common violation under the Fair Labor Standards Act. And it can result in back wages, double damages, attorney's fees, and sometimes even like personal or individual liability for company owners or managers. So be very careful there. Okay, everyone, we're going to move on to number 3, and that is the proper classification of your employees. Now, I know this sounds kind of similar to number 2. Under number 2, as we just finished that area, that highlights the proper classification of your workers. And I even make quick mention there that the proper classification of your workers may invite, or is just as important as the proper classification of your employees. Under number 2, we look at your workers and we have to assess them. That's you. You have to make that assessment with your counsel. And you're assessing those individuals to put them in the category either as an employee or as an independent contractor. But under number 3, we're also going to focus on the next level of that, which is the proper classification of your employees. You either have to classify them as an exempt employee or a non-exempt employee. Okay? Now, for exempt employees, and before I start at some brief information about each of those classifications, exempt and non-exempt, I will have to say that it's not a one-size-fits-all situation. It's not really a general rule where you can kind of make everything fit in that rule. When I go over the definitions of each of these, it's really going to take a lot of conversation and review of documentation by employment counsel and other departments within your organization to confirm proper classification. But in general, an exempt employee is an individual who meets a certain salary threshold. They're typically paid on an annual basis and they perform specific duties. It's that simple in definition, but not that simple when it comes to arriving at your final conclusion as to whether or not that's the proper classification. Okay? When it comes to non-exempt employees, there are individuals who are paid on an hourly basis. They are paid either a federal or state minimum wage, whichever is higher, and a non-exempt employee is absolutely, unequivocally entitled to overtime pay, and there is no way around that. Let's move on to number 4. Number 4 is about overtime, and it's not going to take me very long to get through this. It's very simple. Non-exempt employees are to be paid one time and a half of their regular rate of pay for any and all hours worked over 40 in one work week. I'll say that again. All non-exempt employees are to be paid one time and a half for all hours worked over 40 for one work week. So when that happens, for any work that is carried on behalf of the company, and I'm going to say any work, but this is not legal guidance. This is just for educational and informational purposes only, and it prompts you and should catapult you into a conversation and a relationship with an employment attorney. When you're dealing with overtime, it's nothing to play with. The Department of Labor and the Fair Labor Standards Act requires that non-exempt employees be paid overtime. And any hours over 40 cannot be averaged or pushed into some other time period, other calendar period, other month, another week. If it is earned for that one work week, and it's anything above 40 hours worked for that one work week, it must be paid. Period. Moving on to number 5, record keeping. Now, the Fair Labor Standards Act, I always have trouble saying that. I don't know what it is. The FLSA. It requires for employers to maintain accurate records, and it's pretty simple. It's records that will contain the names of your employees, their addresses, gender, social security numbers, collective bargaining agreements, work hours, payroll records, things of that sort. So, and it could be some other things too, depending on other aspects like what is your pattern of practice or your industry, what are state laws. Okay, so this is the part of the conversation you should be bringing to your counsel so that there's a proper assessment. And sometimes you have to even consider privacy laws and other state laws, not only federal, but state laws, to determine what your company records should look like. That's it. This is the end of the 5 things that employers should know about the FLSA. It's that simple. We talked about the determination of whether you are a covered employer. That's what you should be thinking about and discussing with your counsel. The proper classification of workers, proper classification of employees, overtime pay, record keeping. Yeah, those are the 5 things to consider and to know about under FLSA. Thanks for watching this video. This is a new channel. I'm so excited to finally be doing this. I'm going to be very selective in the information that I share on this channel because it is important for me to start your 360-degree view conversation with your counsel. If you have any questions for me, my email is in the description box below. Thanks for stopping by. Thanks for watching. Like, share, subscribe, comment. I'll see you next time.